This video is Orders of Protection. What information is needed to request an order of protection? Brought to you by the New Mexico Judiciary and presented by Rosemary Traub and Sarah Coffey. The information presented in this video does not and is not intended to constitute legal advice. All information in this video is for general informational purposes only. Information in this video may not constitute the most up-to-date legal or other information. Viewers of this video should contact an attorney to obtain advice with respect to any particular legal matter. Only your individual attorney can provide assurances that the information contained herein is applicable to your particular situation. The views expressed in this video are those of the author or authors only.
We are going to move on to actually the process or how to get a request an order of protection. And so I'm going to start by giving you an overview, and then we're going to go into the details on that. So to open a case, a petition needs to be filed. And it could be what's called a petition, a counter petition, or a reverse caption petition. And I'll go through each one. If there has never been a case filed and one will be and it's opened, and you want to request an order of protection, you will be the petitioner and a petition will be filed. And what could happen later on is that the other party, who is the respondent, could file a petition against you. It's not uncommon. That is called a counter petition. The respondent would have to be served with your petition, and you would have to be served with the counter petition. Now, there's something else called a reverse caption petition. Let's say that in 2015, there was an order of protection case. So there's one already existing. And whether or not an order of protection had been granted back in 2015, let's say that you were the petitioner and your former partner was the respondent. Something may come up now in 2021, and the respondent goes in and wants to request an order of protection against you. Excuse me. A new case would not be opened. That person would file a reverse caption petition, and you'd have to be served with it. When you come in to file a petition, you will be given the paperwork. It's all standard paperwork that is approved by the New Mexico Supreme Court. My suggestion to you, and this is after reviewing hundreds and hundreds, maybe thousands of petitions, is to please take your time, fill them out completely all the way through. There are several documents. They are written and laid out very clearly, but what's really important is to be thorough and clear about what happened, what you're asking for, and the information that's being requested. Once you have filled that out and turned it in, the clerks will provide it to the special commissioner or hearing officer who's assigned to the case. And it will be reviewed. And what we're doing is determining if there is probable cause that an act of domestic abuse, stalking, or sexual abuse occurred. If in the review it is found that there's probable cause, then we will assign a temporary order of protection and order to appear. At that point, you will be provided with your copy of the paperwork, and the set of paperwork to be served on the other individual will be sent to the sheriff's office, so long as there is an address where that person can be served. If you do not have information on where that person can be served, it will be your responsibility to find someone else over the age of 18 to assist you in serving that person. It could be a private process server, it could be a relative or a friend. In the temporary order protection that you get, there is a hearing that will be scheduled within 10 days, which is required under the law. Please read through the entire temporary order protection so that you know what the hearing officer has allowed during the time before the 10-day hearing, and so that you know the date and the time of the hearing. And at this point in time, all hearings in the Second Judicial District Court are by telephone. Sarah?
So let's talk about the petition, which is pretty much you telling the court what's been going on and why you need the temporary order of protection issued to you. So this is a form that you will get when you go to the court or request a petition from the court. It's in a pre-approved form that the Supreme Court has made. So it's a specific form that I'm talking about. Most of it's fairly self-explanatory. You go through, you put your name and the person's name you're filing against, you explain what your relationship is with them, and answer the questions in the petition. So specifically, there is a part for listing allegations. It asks for what kind of physical abuse and other abuse that you have been experiencing. And in this section, you need to list the most recent acts of domestic abuse. So the court is usually looking for more recent acts of domestic abuse unless there's a specific reason that there's a delay in filing. So the most recent acts of domestic abuse, if abuse has been happening over the course of the last 5 years, focus on what's happened recently. The most violent behavior. So if there has been a wide variety of abuse, ranging from emotional abuse to physical abuse, put in the most violent physical abuse in this form. You can include the other information, but you definitely want to include the violent behavior and spend more time on that. List whether weapons were involved. If there was a threat made with a gun, you need to list the fact that there was a gun involved, because this is really important that the commissioner know that this isn't just a threat that someone is going to do something, that this is a threat when they had a weapon. If children were the victims of abuse, you should include that information. So if the person was acting violently towards you and your children, make sure and include the fact that the children were victims as well. If the person was acting violently in front of the children, you can include that information too. You want dates whenever possible. Sometimes it's really hard to know the exact date of when things happened, especially if it's a pattern of behavior. If you don't know the exact date that it happened, think about, the closest you can get. Can you say it happened in late March? Can you say it happened in the month of October? The closest and most narrow date you can give will be better. Obviously, if you can say this happened on June 16th, list June 16th and then the year. But if you can't get that specific, list something there. You need to give them some idea of when this happened, because if it happened in 2003, it's going to be different than if it happened in 2020. And then you want to list where the domestic abuse took place, just to give them some idea, to give the court a little bit of an idea of what's going on. And there's a specific section of that. Now, you can have one sheet that's a blank paper, just a lined paper, to give a detailed statement of what's going on. It's usually good to fill out this sheet and not just put the little tiny, 1 or 2 sentence things. Giving more detail is usually better. However, if there's a whole lot there, you really need to narrow it down to what has happened recently, most violent, because you only get one sheet. You can't write in the margins of that sheet because it gets scanned into the court system, and the court system doesn't recognize anything that's written in the margins, and you don't want information left out. You want the court to be able to look at everything that you wrote. So you write in the lines on that one sheet. The important thing here is to write legibly. I know that sounds silly, but someone has to read it. The court has to read it. So if you're writing something, you need to take a breath. Sometimes it's really hard to write about what you're writing about. Take some time and actually write it out to make sure that the court can read it properly. Because if they can't read it, they don't know what you're alleging. And it's very important that they know everything. Then in the petition for order protection, the other very important thing to look at is there is a page for what you're requesting. This is saying, court, I want you to do this. And you want to make sure and read each option very carefully and check off all options that you think you might need. Even if you're looking at it and say, okay, well, I don't have any medical bills yet because of the domestic abuse. If you did go to the doctor or if you did start seeing a counselor, you might have some medical bills afterwards. So go ahead and check that off. It's always better to ask for more things than not ask for them. Because if down the road, you end up saying, I really need to see a counselor over this, but I can't afford the counseling session, you can ask the court to, have the other party reimburse you for some of that. So go ahead and check it off. If you don't need it, you can tell the commissioner that you no longer need it. So look at that page of requests, read each option very carefully, and make your choices based on what's best for you.
So I previously mentioned that the other person needed to be served. And service of process is just a fancy word for getting the paperwork to the other person so that they have notice of the hearing and an opportunity to be at the hearing. And because there cannot be a hearing unless and until the other person is personally served. In the packet of information that you will be given by the domestic violence clerk, there is something called an information sheet. It is one of the most crucial documents. They're all important, but this is information that really only you probably know about the other individual, where they're staying, say they're staying with their sister, or they've moved to Farmington or whatever. So, and information about them. It's important, number one, for service of process, and may be important to the hearing officer during the hearing. Okay, so list any address, phone number that you have for the other individual, because that paperwork is going to go over to the sheriff's office and they're going to send out a deputy to serve that person. And you want to make that as easy as possible and as successful as possible, because once that person is served, the hearing can be held. As I said, it must be personally served on the individual. Now, if you do not know where the other person is, and that certainly happens, it will not be sent over to the sheriff's office. And that's because they are not going to send out a deputy to just investigate and try and find this individual. They go out based on the information that is given to them. So if you don't have information on the whereabouts of the other person, their documents that need to be served on them will be given back to you, and you will need to find somebody to assist you in getting that person personally served. It can be somebody over the age of 18 years old who's a resident of New Mexico. And it could be a friend, could be a brother, another family member, it could be a private process server. And the paperwork, or let's say that the other person is contacting you or coming by. You could call the police and or threatens that they're going to come by. I wouldn't want them to do that, but it does happen. And you could call police and say, I have an order of protection. This person keeps coming by, keeps driving by, or is going over to my grandmother's house to see the kids, and I need to get him served. And the law enforcement may be able to be of assistance to you. I wouldn't rely on that because it'd be very hard to know when the other person would be around. So it's better to find somebody and to serve the other person. And if they are able to do that, there's also a document provided called a return of service or affidavit of service that the person who is helping you to serve that person needs to fill out, stating when they serve the person, they need to sign it, and it needs to be brought back to the court and filed so that the court knows that the other person has been served. Once the court knows that the other person has been served and has notice of the hearing, then the hearing can proceed on the date that it's scheduled. At that point, it doesn't matter if the other person shows up or not. If they have notice and opportunity to be heard, that's what service of process is all about. Sarah?
So let's talk a little bit about what's going on right now, because right now we are in the middle of the COVID-19 pandemic and everything has had to change just a little bit to ensure everyone's safety. So as of right now, if you need to file a petition, you can go to the court and file a petition. That you can still go through that process just as you did before the COVID-19 pandemic hit. But there's also an option that you can email in a petition. So you can email a petition, the court will then review that petition and email you back the temporary order of protection if it is issued. So there's a little bit more open to you if you're not able or not well enough to be out and about. The hearings themselves have changed significantly because the hearings are being conducted over the phone. Prior to COVID-19 hitting, hearings happened in person. You would go down to the courthouse and go in front of the commissioner. Now you call in 15 minutes before the hearing. You call into the clerk's office, tell them that you have a hearing, and they will give you a phone number to call exactly at the time of hearing. So that'll be a 1-800 number, and they'll give you an access code. Now you need to wait until exactly your time of hearing because these commissioners have hearings one after another. And you don't want to call in early because the commissioner's probably in a different hearing. So call in the 1-800 number that the clerk gives you right at the time of your hearing. The other thing that's important is that if the hearing gets reset, so as Rosemary was talking about with the potential for service, if the hearing is reset, you might need to go down to the court to pick up paperwork, or you might have it emailed to you. Make sure and talk to the clerk about what you need to do because you don't want to miss your next hearing because you don't do it. If you have questions, call the clerks and ask questions. They will be happy to assist you.